Any mention?
Ship, I beg to mention item number 9.
Yes.
Matter may come up after 3 weeks or 4 weeks. Similar matter is pending before the division bench.
Your Lordship, I'm appearing for the private respondents in this matter.
Yes. 3 weeks. Yes. Make it 3 weeks in private petition. Yes.
And Your Lordship, item number 12 and 13, this also connected matter pending before DB, Your Lordship. 12 and 13.
12 and 13.
Yes, Your Lordship.
Yes. 3 weeks in?
3 weeks, yes.
Yes.
Highly obliged, Your Lordship.
The private respondent. Yes.
May I please, Lordship? I beg to mention item number 5, Lordship. I humbly pray may this matter take up after 2 weeks, Lordship.
No objection, Your Lordship. No objection, Your Lordship.
2 weeks in the private. Yes.
Much obliged, Lordship.
Supplementary cause list, item number 1.
Yes, Mr.
My lord, the learned advocate general, will be coming, my lord. My apologies, my lord, for
At the end of the board. At the end of the board.
keep it.
Cause list, item number 1. Yes.
Lordship, I for the respondent, Your Lordship.
Yes.
I beg that this matter may kindly be taken up after 2 weeks, Your Lordship. The conducting counsel has to urgently leave last night, Your Lordship.
No one is for the appearing for the petitioner.
Mr. Chakrabarti was the petitioner.
None appears for the petitioner. On prayer made by MS. Is in
Ace AM, Your Lordship.
and the counsel appearing for the respondent. List is met after 2 weeks.
Highly obliged.
Yes.
Item number 2.
Please, Lordship. This matter, I filed my affidavit in opposition, Lordship, on the last occasion. Can be listed for hearing.
Because I will be seeking 2 weeks for filing my rejoinder in this matter.
Yes. Mr. Petty. Mr. State will. Yes. Mr. Petty Sangha, Rana counsel appearing for the respondent to submits. That affidavit on behalf of the. Oh, that is already been filed. It's in the last occasion you have said, isn't it?
Yes, yes.
Yes.
It's fine.
Oh, that is. You were given time earlier also.
Yes, my lordship.
Mr. Pandey, Rana counsel appearing for the petitioner. Praise for and granted further 2 weeks time for filing rejoinder to the epidemic opposition of the respondent. List accordingly. Yes.
Item number 3.
Yes.
Lordship, Mr. Senior Advocate A. Kumar is on legs in court too, Lordship.
Who is the other side?
Mr. Jindal.
So you cannot keep all the matters pending. The other one also. At least somebody should be here.
We come at the end of the board, Your Lordship. We come on the end of the board, Your Lordship.
There's already one matter for the end of the board. Call it later. Yes.
Item number 3.
Lordship, this matter, I have filed the affidavit bringing on record the annexures in the FIR, Lordship. But Mr. S. Chakrabarti is appearing, petitioner.
You have brought into record
Yes, Lordship.
what you said?
Beneath you. I filed it on the 11th August, Lordship. The documents enclosed in the FIR.
It is none appears for the petitioner.
Please, Your Lordship. I apologize for my late, Your Lordship. Lordship, in this matter, they have filed the affidavit, so the conducting senior counsel is coming, so it will be taken up at the end of the board, Your Lordship.
We have already 2-3 matters at the end of the board. We are not having. We will have it after vacation. It's submitted by Mr. Karni. And the affidavit has been filed. Bringing on record the documents which were enclosed, may I record the documents which were enclosed with the FIR dated 19/9/2023. You have received the affidavit?
I have filed.
Yes.
Oh, I have, sir.
Mr. So-and-so, Learned Counsel appearing for the petitioner, acknowledges the receipt of this affidavit. That's right. This is matter after 2 weeks.
Oh, bless you.
Highly obliged.
The cause list hearing item number 4.
Yes.
May it please your Lordship. Lordship, Sir K.P. Bhattacharya is appearing for the petitioner's Lordship. He's not here.
None appears for the petitioner. Why no one is here? Why? What is the problem? None appears for the petitioner. Unless Sugra Learned Counsel is present on behalf of the respondent. List after 2 weeks.
Right, Lordship.
Item number 6.
Yes. Yes, Mr. Pandit.
This is a matter where pleadings as such are complete.
Lordship, before here I have filed a business application, Lordship, to implead the chairman of the locality as a party, Lordship. Just wanted to, I want to make submission on the
Where is that
application.
miscase? What is that miscase? Miscase number? What is the number of this miscase? 2. Yes, miscase number 2. Yes.
Application. This is Kingston. Okay. Sanjay, give Sanjay. Sanjay, miscase application. No, Sanjay.
Yes, Mr. Jindal, you'll represent this Lakayukta.
Yes.
Do you have any objection to your impleadment here?
My lord, previously also I had submitted that I leave it to the wisdom of this honorable court.
Whether you are having any objection or not, there is the thing.
No.
Your objection, you cannot leave it to this thing. Either you say yes or
there is no
you-
objection. There is no objection.
Then we'll implead Lokayukta as a party here.
Well, the only difficulty is that as such the pleadings in these matters are complete, and the matter has been remitted after the Lokayukta to the special court, and state of Meghalaya has already been made a party. The private respondent is also a party to contest the allegations made in the petition.
You have challenged the jurisdiction of Lokayukta, isn't it?
Yes, my lords, we have
Is
challenged.
it not proper that we give an opportunity or their participation will help our adjudication?
Because the difficulty, my lords, the situation is this, that the tribunal as such is not required to defend its orders.
No, but then what is the problem if it comes and joins?
My lords,
When
then,
it itself has no objection.
my lords, the only issue is that it will again initiate a process of filing and pleadings and so on and so forth. I have no difficulty. My lords,
It may
that-
not be. It may not be.
Lords, may I plead Lokayukta, that's...
Yes. The Miss Case number 2 of 2023. Card Mr. P.T. Soma, Learned Counsel. Preparing for the applicant. And also Mr. Pandey, Learned Counsel, preparing for the respondent number 1 and 2. And Mr. So-and-so. Then you say also heard Mr. Jindal, Learned Counsel, appearing for the Lokayukta, chairperson Meghalaya Lokayukta, appearing for chairperson and appearing for chairperson and the secretary Meghalaya Lokayukta Shillong. Who are sought to be impleaded as party respondent in writ petition criminal number 2 of 2023. It is submitted by the Honorable Counsel for the applicant that the jurisdiction and authority of the parties sought to be implemented has been challenged in the main writ petition. And their participation in the matter will help the court to come into a proper finding in the matter. Proper finding step. Mr. Jindal, Learned Counsel, appearing for the parties sought to be included in the writ petition, has no objection to the claim made in the application. Stop. Here paragraph. It appears on the perusal of the writ petition that the one of the contention raised by the writ petitioner is with regard to the jurisdiction of the Lokayukta who passed the impugned order in the writ petition. It therefore follows that participation of the Meghalaya Lokayukta will help, who will render assistance to the court in adjudication of the main writ petition. Stop. Give a paragraph. For the reasons I proceeded, this miscellaneous application stands allowed. The chairperson Meghalaya Lokayukta Shillong and the secretary Meghalaya Lokayukta Shillong are implemented as the respondent number 3 and 4 in the writ petition criminal number 2 of 2023. Stop. This application stands allowed. Oh, this is already safe. If you said, then avoid it. And then come to the main writ petition. Just say, in view of the order passed in Miss case number 2 of 2024. The chairman Meghalaya Lokayukta Shillong and the secretary Lokayukta Shillong are implemented as respondent number 3 and 4 to this writ petition. The registry shall make the necessary correction in the cause list of the writ petition. We are not burdening you. Then when shall we hear the writ petition then?
My lord, if a copy of the writ petition could kindly be supplied to me, my lord.
We'll do that.
Stop. The petitioner is directed to furnish a copy of the writ petition to Mr. General Learned Counsel appearing for the newly implemented respondents. Newly respondent, respondent number 3 and 4. Sure, furnish. We do not need a judicial order for doing that. Anyway, let it.
No, we'll furnish that. That'll be done.
When shall we have it then?
Up 2 weeks, man. Yes, 2 weeks.
Yes. As fair for the parties, list this matter after. List on this matter. List is on this matter after 2 weeks. Yes.
Because if I may seek your lordship's indulgence as far as one more thing, my lords, we are, my lords, moving similar petitions, my lords, 2 more petitions which are there, my lords, fixed for the hearing of charge, and similar, my lords, situation is there. I am seeking your lordship's indulgence if the matters could be taken up, my lords, tomorrow, because it is fixed for hearing on charge. My lords,
No, not possible. We will not madam. There are many matters. Court will not have time to do that.
my lords,
You have to wait for your turn. These are already pending matters. Matters are pending.
no, my lords, these are fresh matters.
No, you file it, they will just see it in the usual course.
Because the difficulty is that those matters are, my lords, fixed for framing of charges, my lords, tomorrow. That is why we are seeking that your
You
lordship.
should have filed it before then. You file it, it will come in the usual course. It will be listed. If it is charges framed also, that will not harm. And this is not the time also to make a mention for it.
No, my lords, that is why I sought your lordship. I apologize, my lords, for
I
that.
would not like to give too much indulgence.
7.
So same we have please.
My lord, in item number 7, I'm petitioner.
Respondent number 3 and 4.
The respondent numbers will change, my lord.
Respondent numbers will change.
I'll be, my lord, newly implemented 10 and 11.
In that second application. What is
No, not 10 and 11. There are the number of petitioners. The writ petitioners are many, lordship. The respondent numbers will be 3 and 4 only. The chairman and
3 and 4.
Oh,
Okay.
Yes, lordship.
Same order. Same order.
Similar order, lordship. Only the miscase number and writ petition number will change.
Yes. Representative, and then you record the name of Dr. P. Agarwal. Yes. There also you supply a copy.
Yes, lordship. Yes.
Item number 8.
Item 8, Mr. Thapa is appearing.
None appears to the petitioner. Mr. Karmi is present. We have the state respondents.
Your Lordship.
List after 3 weeks. We'll have it after 3 weeks.
Yes, Lordship.
Yes.
Your Lordship.
Okay, we will come back then. Yes, we'll come back.
Lords,
Yes.
Wait, please, Your Lordship, let this matter become at the end of the board.
end of the board. Lords.
There are 3-4 matters already for the end of the board. We have kept it. We cannot. This court cannot function after vacation. After vacation.
10 and 11, my lord, they are together.
There are already 3 matters there.
Lordship, I'm appearing for the state in item 10.
Yes.
11, Your Lordship.
10 and 11.
Let's just say it is. Just tell what is your name?
H. Noplor.
Yes. What is the difficulty here?
He's on leg, Your Lordship.
That is submitted by
No, he's not agreeing. After vacation.
so and so that Mr. S. Dev learned Arvind Council is occupied in some other court. We have the submission. This is matter after vacation. After vacation.
2 weeks, Lord.
After 2 weeks, okay.
My lord, may I make a request, my lord?
Yes.
Because, my lord, there is another analogous matter which is listed on the 9th, my lord, Anuja and Bora. If this matter is also listed together
We'll
with
see
these matters.
when that matter comes up. We'll just see. On the 9th, who are the party there? Who are the lawyers there in that?
My lord, the petitioner counsel is Sir B.K. Jindal.
Pertaining to the same FIR.
Oh, there is quashing of FIR.
Yes, my lord.
The same FIR.
Same FIR, my lord.
Okay, then you do one thing. Then just say like just so and so. So and so is okay and so and so.
It's the same
It is the same FIR, my lord.
Same FIR.
Same FIR.
Let us see, Mr. Jindal, if we are not taking it together, we will just listing it on 9th. We'll just see. If it is the same FIR, then we'll take it up. If it is not the same FIR, then we will not take it up.
There are 2 FIR.
Yes. Okay, we'll just see it. We'll just see it. Just what we said, so and so and so. Then you just change it. Just say on request made by the parties, learning council appearing for the parties, list this matter on 9th.
And update, Your Lordship.
All right, my lord.
Obliged, Lordship.
Wait,
Yes.
please, Your Lordship. Your Lordship, I'm praying for some accommodation. Mr. Shulai is leading this matter and he's on lines, Your Lordship.
What is this matter about?
Your Lordship, this is an application to quash the FIR dated 16/6/2017 and the GR proceedings and the order passed by Judicial Magistrate First Class.
Okay. Oh, that was the matter which was taken up.
Yes,
Okay, we'll have it this thing.
May it please, Lord, I'm sorry, Your Lordship. Lordship, I got that judgment, Your Lordship, but I'm sorry I forgot it at home, Your Lord. That I'll bring, I'll please before on the next year.
Then just press on plan made by Mr. Andy Shulai, non-AG, appearing for the state respondents. This is matter after 2 weeks.
Lordship, 2 weeks, Lordship, yes. Highly obliged, Your Lordship.
Yes.
Lordship, this instant petition is filed for quashing of FIR dated 2nd January 2025.
Yes.
Lordship, this instant petition is filed by respondent number 2, who is the sister of respondent number 3. He is the victim. Respondent number 3 is the victim. Lordship, this FIR was lodged.
How many private respondents are there?
There are 3 private respondents.
Two private respondents.
Yes, one is the
They are
complainant.
represented both for both the.
Yes, Lord.
The private respondents are sisters.
Victim and the
Sister. Oh,
They are related as
they are brother and
brother
sister.
and sister. Okay, sister and brother.
Yes.
Okay. Okay.
Lordship, and moreover, this the petitioner and respondent number 3.
Who is the victim? Who is the victim?
Victim is respondent number 3.
Respondent number 3.
They are brother-in-law.
Okay.
Lordship, this FIR was filed in Madanriting Police Station by respondent number 2, and it was registered as Madanriting PS Case 1 of 2025 under Section 109, 1 and 118, of BNS.
This is corresponding to what in the IPC? What is the
E
corresponding sanctions in IPC?
IPC is 302 and 307.
Attempt to murder. Attempt to murder, right?
Yes, attempt to murder. 307 and 306, 26.
Grave assault, causing grave assault. Yes.
Yes. May I?
Yes, please go. But you have to tell the court the offence.
Yes, Your Honor.
You must know the nature of offence before you. Yes.
Your Honor, may I read the section?
You do not have to read. We can understood. We can understand now. Yes.
Your Honor, the actual fact of the case is that on the 1st of January 2025, the incident took place on January 1, 2025. The petitioner, along with his family, went for a New Year celebration. While coming back from the picnic, the respondent number 3 was in a drunken stage and he was assaulting his wife. Being concerned of his sister-in-law, the petitioner told him to behave well with him, which I have mentioned in my para 7, the actual fact of the case. So, as he was telling him to behave well and not to conduct such action against his wife, so on that argument was started, argument was heated. Later, the petitioner left the place of occurrence. While he was proceeding toward his house, the victim hit him from behind. So unintentionally, while he was proceeding toward his house, he was carrying a picnic staff, which unintentionally, while turning back, he hit the victim on his chest portion, where there is an injury sustained.
For how long victim had to remain in hospital?
He remained in the hospital for 4 days.
4 days.
4 days.
And what is the requirement of law to constitute an offence under Section 326? Is there any requirement?
Yes, the main ingredients is intention and knowledge should be there.
So far as the medical condition is concerned,
there should be a grievous heart.
How do we establish grievous heart? How do we distinguish it? Is there anything provided here? Whether there is a requirement that the patient should be treated as indoor patient in some hospital for some days?
Yes, Your Honor. If it's a grievous heart, he should be stay in the hospital for 20 days.
Yes. So here he did not pay.
Yes,
pay for
he
20
stayed
days.
only for 6 days. Thereafter, Lordship, when the respondent number two who have filed the FIR, after knowing the actual incident, so he went to the police station on the next day, which I have mentioned in my para 9 of the petition. For withdrawing the case, for withdrawing the FIR, as they have settled them, as they have compromised between them. But the investigation officer could not take into consideration, since the section are non-compoundable. 109 of BNS is there, which is 307 in IPC. So he advised him to go appeal before this Honorable High Court. So with that, Your Lordship, I have mentioned in my para 10, with the petitioner and the respondent 2 and 3, along with his family, they decided to settle the matter amicably by making settlement agreement, which they have made on 24/4 of 2025, which is in my annexure 6, page 24. Your Honor, may I read out the settlement agreement, which is in page 25.
Yes.
Your Honor, I'll just read out the relevant portion, that all of us had come to settlement that since being from the same family, if the case is charge sheeted or proceed against Sri Short Distance Singh Marbo, it will be adversely affect the peace and harmony of the family, as well as the wife of Short Distance Marbo shall suffer irreparable loss, injury without any fault. Lordship, I have mentioned that they belong to the same family. They are brother-in-law in relation and they belong to the same kur. So they are staying in the same compound. Lordship, I would like to rely on judgment which has been passed by the Supreme Court in Nashili versus State of UP and others. I may supply the copy.
This is what reported in which year?
2025. Lordship, in this instant judgment, the fact of the case is almost similar of my case.
There also section 307 was involved.
Yes, Lordship.
Yes.
Where both the parties came to settle their matter before the Honorable High Court of Allahabad. The Honorable High Court of Allahabad dismissed the application, holding that the case involved section 307 of IPC, and it cannot be quashed with the compromise deed. Being aggravate, therefore, an appeal was preferred before the Supreme Court, before the Honorable Supreme Court. The Honorable Supreme Court has stated in para 20. Lordship, may kindly turn to para 20.
There is another decision of 2019, so far as section 307 is concerned. Otherwise, leading decision is that Gyanshing's case. Gyanshing and...
Yes.
They refer in this judgment also, my lord. They refer Gyanshing.
And there was another matter probably reported in 2019-20. It is concerning section 307.
Lordship, I may read out the relevant portion.
Oh, that is there. That also has been.
Yes.
This state of Madhya Pradesh, Lakshmi Narayan. Yes.
Lordship.
My lord, I have a copy of the judgment if you would like to see.
Which one? We do not need. If you are you disputing any of the propositions ought to be then it's okay. Yes, please.
Lordship, I'll go to para 20 of line 11. We make it clear that we are seeing so on the fact of the present case. We are firmly of the opinion that the proceeding...
Just read the whole paragraph. Why you are reading from this thing? It's not a very big paragraph. Yes. Read. So that we can also understand.
Yes, Lordship.
Yes.
We are also inclined to conclude that considering overall circumstances that the nature of weapon and the nature of injury, the offence alleged on the fact does not fall in the category of the case where the court should deny relief in the event of settlement. At the highest of the offence alleged could be under section 326 of IPC, it could not be said on the fact, considering all the circumstances, that this is a crime which has such harmful effect on public and that it has effect seriously threatening the well-being of the society. We make it clear that we are saying so on the fact of the present case. We are also firmly of the opinion that the proceeding with the trial, when the party have amicably resolved the dispute in the present case, would be futile, and the end of justice required that the settlement given effect to by quashing the proceeding. It would be grave abuse of the process to let this trial remain pending under above circumstances, particularly when the dispute is settled and resolved. Lordship, I would like to take you again to para 22, sub-para 19. Where the Honorable Supreme Court had laid down some power under section 428 CRPC, now 528 B and SS, Wide amplitude ought to be exercised carefully in context of quashing FIR proceeding bearing
You are reading paragraph?
paragraph 22, paragraph 22,
Yes.
subpara 19, 19.1. We ought to exercise carefully in context of quashing criminal proceeding, bearing in mind nature and effect of the offence on the society, seriousness of the injury, voluntary nature of the compromise between the accused and the victim, and thirdly, conduct of the accused person prior and after the occurrence of the purported offence and other relevant consideration. Lordship, Lordship, my humble submission is that since there is no prima facie as the main ingredient of Section 109 and 188, Clause 1 of BNS, where intention and knowledge should be there before conducting any act are not present, and as such the petitioner is with this instant application. And moreover, Lordship, as they have correspondingly, as they have settled the matter amicably, and they all belong from a same family, and since they have decided to forgive and forget each other through this settlement, the quashing of this instant FIR shall bring peace and harmony among the family. Lordship, this is my humble submission. So, as the compromise is also done voluntary between them, and there is no offence committed by the victim or by the accused before or thereafter, and they have written in the settlement clearly that they will not conduct any such incident in thereafter. And Lordship, if we see the injuries sustained, if we go to the medical report also, it's in annexure. Lordship, it's in annexure 4, page 20, where the impression study revealed that the study revealed that moderate amount of cruller collection on the left, and there is also a mild pneumothorax on the left, consolidation in lower lobe and cruller thickening with calcification are seen on the right. There is a surgical emphysema and mysofacial edema along with the left chest. Your Honor, here pneumothorax, this is a condition where occurs when the air leaks into the space between the lungs and the chest wall, and this is, as they have revealed in the medical report, it is a moderate amount. It is not that severe.
The victim needed surgery.
Yes.
There was a need to undergo surgery. Was it life-threatening?
No, Lordship, because it's just a mild. This surgical emphasis also happened because of severe taking of smoking also, Lordship. The thick layer where the air passes through, because it happens through smoking also, Lordship.
That we do not know. That we cannot determine here. So we cannot go by that probability.
Lordship.
But then the thing happens that this entire medical condition had arisen because of the injury received.
Lordship.
Isn't it? Yes, madam.
Yes, my lord. May it please your lordship. My lord, the incident occurred on the 1st, 2025. FIR was on the second day, that is the 2nd, 1st, 25. Compromise was, of course, his medical report was as per the same day, 2nd, 1st, 25. because of the incident and because of course, the injury to his chest portion. Then also, my lord, the compromise happened 29 days after, that is on the 30th, 1st, 2025, the settlement. So there was no charge sheet after that, my lord. I do not know, maybe because of the settlement.
matter was not investigated
No,
thereafter.
it was not, my lord. So of course, we also rely on the same judgment, my lord, and I'll read only the relevant paragraph of the same judgment, which
Whether you are having any objection to the prayer made,
no, my lord, we don't have objections to the settlement.
that will be good enough for this.
Because first, why we don't have objection to settlement, my lord, is because this dispute, alteration arised out of a matrimonial,
Dispute.
Yes, dispute. So because of this and because of this peacekeeping in the family, there are judgments that say that you can compromise on such incident, particularly when it comes to the peace matrimonial. I will read this. I will refer to the relevant para, my lord, of the same judgment.
What page?
The same judgment of
Page?
I'll let you know, my lord, of Nose, Ali, 2025 SSC online, SC 292.
This is the
The
same
para is
judgment.
58, my lord.
You are referring from the same judgment.
The same judgment, my
But
lord.
then we will not get here. It will not tally here because the copy I am holding
Yes, my lord.
is not that what you
I
are.
will give you the copy, my lord. I have a copy. It's here.
Paragraph?
Sorry, my lord, this is of Gyan Singh. I'll give you Gyan Singh's judgment. Sorry, my lord. Because Nasi refers to Gyan Singh, I'll give you Gyan Singh's judgment. 2 minutes, please. Here, Lord. Sorry, my lord. Para 58. Where may I read, my lord?
Just a minute.
It is a quote. It has been quoted as Para 58, my lord.
Where the High Court quashes?
Yes, my lord.
Oh, yes.
Where the High Court, may I read, my lord?
Yes.
When the High Court quashes a criminal proceeding having regard to the fact that the dispute between the offender and the victim has been settled, although the offences are not compoundable, it does so as, in its opinion, continuation of criminal proceedings will be an exercise in futility, and justice, in the case, demands that the dispute between the parties is put to an end and peace is restored, securing the ends of justice being the ultimate guiding factor. No doubt, crimes are acts which have harmful effect on the public and consist in wrongdoing that seriously endangers and threatens the well-being of the society. It is not safe to leave the crime doer only because he and the victim have settled the dispute amicably or that the victim has been paid compensation, yet certain crimes have been made compoundable in law, or without the permission of the court, in respect of serious offences like murder, rape, dacoity, etc., and other offences of mental depravity under IPC, or offences of moral turpitude under special statutes like Prevention of Corruption Act, or the offences committed by public servants while working in the capacity of settlement between the offender and the victim, can have no legal sanction at all. However, certain offences which overwhelmingly and predominantly bear civil flavor, having risen out of civil, mercantile, commercial, financial, partnership, or such like transactions, or the offences arising out of matrimonial, particularly relating to dowry, etc., or the family dispute where the wrong is basically to the victim and the offender, and the victim have settled all disputes between them amicably, in respect of the fact that such offences have not been made compoundable. The High Court may, within the framework of its inherent power, quash the criminal proceedings or criminal complaint or FIR if it is satisfied that on the face of such settlement there is hardly any likelihood of the offender being committed, and by not quashing the criminal proceedings, justice shall be casualty, and end of justice shall be defeated. The above list is illustrated and not exhaustive. Then also, my lord, I also have judgments of this High Court, my lord. I'll provide copies, my lord. This is my copy. Yes, my lord. This is 2025 SSC Online Meghalaya 111.
This is judgment by this court.
Yes, my lord. There are a batch of other, these are connected criminal proceedings, my lord, where the FIR is quashed. It is a motor vehicle incident. FIR, the Madan Renting PSK so-and-so registered under section 279, 337, 427, 304 IPC.
That's all right. This court remembers it.
Yes, they
That's
quashed
okay.
these
This
proceedings.
is
And
okay.
then I have another, my lord, another judgment of the same court.
No, you are not satisfied by what you have shown just now. You want something more.
No, my lord, I thought that you will need something of our court also.
No,
Which
just that's okay. See, like there remains no confusion, and since you are not having any objection, then I don't think
this is a
there will
family
be a problem.
settlement, and also because
What is the another judgment? Is with regard to
I
what?
will, yes, I will show you.
That
my
is
lord.
also of this court.
Yes,
of
my
our
lord.
High Court,
Yes, my lord.
and in a matrimonial matter.
No, it is not a matrimonial matter. It's just a settlement, my lord. A settlement because of.
In what case?
I'll just let me take out this confusing with all these papers, my lord. Just let me remove all this. Yes. This is under 498. It's matrimonial matter. 498, 326, and 506 IPC. Should I give you a copy, my lord? It's just a highlight of this judgment. I'll just read. I'm not referring to any paragraph. It's just a synopsis of this judgment. Consequently, this court, having concluded the compromise reached between the parties and is genuine following the dictum of the Apex Court in the case of Narinder Singh, supra at para 29, 29.2 and 29.4. In view of the aforesaid discussion, we sum up and lay down the following principles in which the High Court would be guided in giving adequate treatment to the settlement between the parties and exercising its power under section 482 of the code while accepting the settlement and quashing the proceedings or refusing to accept the settlement with directions to continue with the criminal proceedings. When the parties have reached a settlement on the basis of the petition for quashing the criminal petition proceeding is filed, the guiding factor in such cases would be to secure ends of justice or to prevent abuse of the process of any court, while exercising the power of the High Court is to form an opinion on either of the aforesaid two objectives. 29.4. On the other, those criminal cases having overwhelmingly and predominantly civil character, particularly those arising out of commercial transaction or arising out of matrimonial relationships or family dispute, should be quashed when parties have resolved the entire dispute among themselves. That's it.
Yes.
Lordship, I'm for the respondent number 2 and 3.
Come to side.
Yes.
I have received the information through the petitioner itself. Petitioner called me that some tussle was between the respondent number 3 and between the petitioner. So thereafter, I didn't believe that.
You are appearing for whom? You are appearing for 2, isn't it?
2 and 3.
Now, if you say I, then we should take whom? Respondent number 3 or respondent number 4?
2.
Or respondent 2 or respondent number 3?
Respondent number 2.
So
actually, the respondent number 3 has received the information of the incident from the accused. So after receiving the information, respondent number 2 went to the place of occurrence, and that time the respondent number 3 was unconscious. So I didn't believe, and after that, respondent number 2 went to the police station to file FIR. So when the respondent number 3 get to know regarding the FIR, and he told the actual incident of that had happened on that day. So I went on the next day. The respondent number 3 went to the police station to withdraw the FIR, since they have already registered and they have registered under the non-compatible section. So they told that you have to file for quashing. So I went. After that, with that regards, I have came to the settlement deed, and before I am here before this honorable court today. So, Your Lordship, I have no objection if the matter is quashed.
Okay, we'll pass on. Journey to my room. Yes, all
Obliged.
Send
16.
Yes, thank you.
May it please your Lordship. Lordship, this application has been filed under section 528 of the BNSS 2023 for quashing the FIR dated 16/6/2025 and the criminal proceedings of Lumdinggiri PS case number 80 of 2025. Lordship, the petitioner number 2 had filed an FIR dated 16/6/2025 against the petitioner number 1. Lordship, thereafter, the petitioner number 2 approached the officer in charge of Lumdinggiri PS on 18/6/2025 to withdraw the said FIR. But he was the petitioner number 2 was informed by the said OC that the matter has already been registered as Lumdinggiri PS number 80 of 2025 under section 305A and 331(3) BNS 2023. And as such, he said he cannot do anything and the petitioners had to approach the court of law. Lordship, in the meantime, the petitioner number 1 was hospitalized on 17/6/2025. Thereafter, Your Lordship, the petitioner number 1 was issued notice dated 19/6/2025 by the Jalupara police outpost, and the father of the petitioner number 1, apprehending that the petitioner number 1 would be arrested, had met with the lawyers, and thereafter, Your Lordship, an anticipatory bail application was filed before the Judge, District Council Court, which was registered as bail application number 6 of 2025. And an interim order was passed, Your Lordship. Thereafter, Your Lordship, the both the compromise deed as well as the application for anticipatory bail was signed by the petitioner number 1 when he was still in hospital, Your Lordship. Your Lordship, he was admitted on 17/6/2025 and was discharged on 26/6/2025. Your Lordship, Annexure 4, page 24, Your Lordship. Lordship, since these sections are non-compoundable, we have approached, the petitioners have approached this Honorable Court for quashing the FIR and the proceedings of Lumdingjiri PS number 80 of 2025. Lordship, the compromise deed was executed on 18/6/2025 between the petitioner number 1 and the petitioner number 2. Lordship, petitioner number 2 is the person who filed the FIR against the petitioner number 1, Your Lordship.
Where is the compromise?
Your Lordship.
Where is the compromise?
Your Lordship, Annexure 2, page 19, Your Lordship.
Yes.
Your Lordship, this compromise has been made voluntarily by both the parties without any coercion. And Your Lordship, initially we had filed just the Xerox copy of the compromise deed, and however we have filed the original of the compromise deed via affidavit, which was filed on 27/8/2025, Your Lordship. Your Lordship, the petitioner number 1 is supposed to go for further medical treatment out of station, Your Lordship. And Your Lordship, regarding in the FIR, the name of the petitioner number 2, Lordship, is reflected as Elder L. Nongtrao. Lordship, since he is a church elder and this incident happened at Saumer Presbyterian Church, Lordship, and in the compromise deed dated 18/6/2025, the name of the petitioner number 2 has been shown as Lamjingshai Nongtrao. Your Lordship, in this regard, an affidavit has been made whereby it has been sworn that Elder L. Nongtrao and the petitioner number 2, Lamjingshai Nongtrao, are one and the same person. And this also, Your Lordship, we have brought on record via affidavit filed on 27/8/2025, Lordship. And Lordship, since this is a matter where the complainant as well as the accused have executed a compromise deed dated 18/6/2025, Lordship, I'll just like to place a citation of this Honorable Court in the case of Diprin Nongrum versus the state of Meghalaya, Lordship. Here also, Your Lordship, it is for quashing the FIR, and Your Lordship, a compromise deed was executed between the parties, and this honorable court, on the basis of the compromise deed, was pleased to allow the quashing of the said FIR. Lordship. So, Lordship, I humbly pray that the FIR dated 16/6/2025 and
This is a criminal petition for quashing on the basis of compromise, Lordship. There are a number of judgments passed by your Lordship whereby the criminal proceedings in FIR have been quashed on the basis of the FIR. And not only this judgment rely by my friend, but there are many others also, Lordship. And also in a number of judgments by the Supreme Court, Lordship, it allows quashing on the basis of compromise. And Lordship, I have obtained the instruction from the IO, and also I have met both the parties, and the complainant does not have any objection for quashing of this criminal proceeding, Lordship. And the IO also says the same. So on my behalf also I say I don't have any objection. So Lordship may pass necessary.
Password.
Lordship, the proceedings of Lumdingjiri PS case number 80 of 2025 may also be dropped.
What is your prayer? Is it there in the prayer?
Yes, Your Lordship.
So if it is there in the prayer, so that will be looked into. Lumdingjiri PS case number 80 of 2025.
Yes.
That is what you want.
Yes, Your Lordship. The quashing of the FIR and the proceedings of Lumdingjiri PS case number 80 of 2025.
And this is registered under what section of law?
Under section 305A and 331 subsection.
Is it mentioned in
3.
your petition?
Yes, Your Lordship.
Where it is? Yes. 313. Yes.
Obliged.
17.
Highly obliged.
Because I apologize for not being there in the first call because of some confusion, my lords. This matter, my lords, concerns a challenge to an order passed by the Commercial Court, Shillong, my lords. And the controversy here is in respect of an arbitration clause. So, my lords, the arbitration clause, it is our contention that it is an arbitration clause which provides unilateral power of appointment to one of the parties. And it is a settled principle of law by virtue of the provisions amendments made in the Arbitration Act and also by virtue of various judgments which have been passed since 2015 that there cannot be any unilateral appointment of arbitrator because both parties are mutually consenting to a private tribunal. And if one party is deciding who is going to be the arbitrator, that will lead to justifiable doubts as to what will be the outcome.
What happens if one party remains silent?
Yes, my lords. The judgments, as far as the Supreme Court is concerned, there are judgments, my lord, on silence cannot be taken as consent. Silence in matter of appointment of arbitration cannot be.
Actually, that's a supposing issue. It
Yes.
happens that one of the parties
Right.
do not come forward
Right.
to give consent.
Yes, my lord.
Then what would happen? This will remain. The matter will no arbitrator will be appointed.
No, there are two things, my lords, in this situation, and that is a relevant, my lords, consideration as it will feature in this matter also. So, as far as silence is concerned, first of all, the situation is that the Supreme Court says that firstly there is a line of judgments where they have said that silence is not consent. Secondly, today we have an Arbitration Act which specifically provides for a procedure when there is silence, what to do. Section 11 has provided that procedure. So, as far as silence is concerned, it is not for the other party to take the silence as a consent and go ahead with arbitrator appointed by him. You have to approach the Honorable High Court, and the High Court has generally, my lords, High Court has a panel of arbitrators, and they will appoint a fair-minded arbitrator for deciding the dispute.
So you want to say that in every cases where one of the parties refuse to extend any consent,
yes,
in such a case, the only solution available
Yes.
to the party aggrieved is to approach a court and get an arbitrator appointed.
Get an arbitrator appointed.
So, the clause which empowers otherwise or
yes,
authorizes one of the parties
is
in
called
the event of failure
yes, my lords.
would not be open.
Would
It is
not be. Yes, this is my submission, my
So
lords,
that,
and
that has to be rendered invalid in
invalid. That aspect has to be rendered invalid. That is my precise submission, my lords, contrary to Section 11 of the Arbitration Act. So, my lords, in this case, there is an arbitration clause. The arbitration clause is very simple. That one, it is provides for a
arbitration clause is never said. Never said.
Well, that's, there is, and that is the reason why we are before your lordship in this case, because of the complexities arising out of the arbitration clause. So the arbitration clause, my lords, is this, that there will be a 3-membered arbitration tribunal. One arbitrator will be appointed by the first party, the second arbitrator will be appointed by the second party,
and third by joint.
Both will appoint. Now here, my lords, is the catch in this arbitration clause, because it says that if for some reason the first party appoints its arbitrator and asks you to appoint an arbitrator, and you do not appoint an arbitrator, then the first party's arbitrator will become the sole arbitrator, and the entire dispute will be decided by his nominee. Now, ultimately, what will happen is that who has appointed that arbitrator? You have appointed that arbitrator. The first party has appointed that arbitrator based upon certain considerations that you have appointed.
So then, in such a case, it becomes one-man arbitration.
One-man arbitration appointed by one party. So, what will be my fate in such an arbitration? Because it earlier provided a counterbalancing between the two sides. Today, you have appointed an arbitrator, most likely, my lords, it is fait accompli in these arbitrations. As my lords, it has been generally said that arbitration is decided at the time of appointment of arbitrator. So, the arbitrator has been appointed by one of the parties and it is, my lords, proceeding in this matter. We file an application under section 14 of the Arbitration Act, which says that you can seek for termination of mandate of an arbitrator if there is a de jure or de facto inability. We move to the learned commercial court, my lords. The matter is taken up, my lords. It is heard at length. Various judgments are quoted and cited because there is a long line of judgments on this aspect. And thereafter, in one paragraph, by my lord's contention has been rejected that we do not find favor with your case. So today we are, my lords, before your lordship in that matter under the civil revision petition. So my lords, this is the thing. And in the arbitration, when we proceeded with the application, my lords, it was specifically highlighted that this is the situation. The other side, my lords, appeared and accepted that they will communicate to the arbitrator not to proceed. In the meantime, there were certain talks for settlement between the parties also, but that did not fructify beyond a point. There were certain aspects which were settled, but certain aspects which remained unsettled. In the course of the, my lords, proceedings, the arbitrator has reserved the award. Despite knowing the fact that an application is pending challenging his mandate, and in the last penultimate order, the learned commercial court had to request the counsel of the other side to inform the arbitrator that the matter is pending.
Why there was no interim order by the
commercial
commercial court?
Commercial court, it was, my lords, both sides had in a way, my lords, agreed that they will not. What is the point of having an arbitrator?
Was it reflected in the order?
Yes, my lords, I will show that orders.
And that is okay. You said that is good enough.
Yes, my lords. So that was reflected, my lords, in multiple. 3 orders are there of the commercial.
It was there.
It was there, my lords. So today, my lords, submission is, my lords, till the time, my lords, are hearing this matter, for preserving the list before your lordship, my lords, at least, my lords, directions may be passed to the arbitrator not to release the award, pass the award while the matter is pending before your lordship.
So it not the release the award means like that has matter has proceeded to some extent, to some
extent, my lords, ex parte.
And
That
what is the stage now?
My lords, the arbitrator has reserved the award. As soon as he pronounces the award, this matter becomes infructuous.
So that is at the final stage.
Final stage, my lords. Judgment has been reserved in that sense.
Is there any purpose of like preventing arbitrator to do that at this stage?
No, my lords, if his mandate has been terminated, if I succeed in this petition, then his entire appointment will go, and there will be a fresh proceeding. They have to initiate a fresh proceedings. A fair solution would have been they should have approached this honorable court for appointment of an arbitrator.
When did you file? When this appointment was made, and when did you file?
Right away, my lords. Right away. As soon as we received the information, we approached the High Court, the Commercial Court, my lords. Those dates are there, my lords. I can show from the dates.
Where is the order of the court where this?
Yes,
that is recorded. This arbitration will not proceed. Just pass. Have you enclosed it?
Yes, my lords. That is there. The orders are there, my lords. 3 orders I will indicate, my lords. First order is at page 194 of the petition.
Why there are 2 pagination, Mr. This becomes very confusing. See, your page 96, page 80, one is by blue ink, another is by black ink. Very difficult.
My lords, my friend is telling me the pagination which is circled is the pagination before your lordship.
You should have cancelled the other thing.
Yes, my lord.
You are referring to page?
194, my lords. So, my lord, this is an order dated 5th of September 2024. September 2024, my lords, petitioner is represented by me, Milords, who appeared by VC and praised that proceedings before the arbitrator may be stayed till the disposal of this application. Respondent is represented by Mr. So and so, who submits that the hearing before the arbitrator will take time and is not likely to be concluded on 7 September 2024, and therefore there is no urgency and this application may be heard on a short date. So the respondent says there is no urgency. Had there been an urgency, he would have agreed. Learned counsel submits that the proceeding before arbitrator is at the stage of filing of the statement of claims by respondent and claimant. Petitioner herein is yet to appear. Considering the submissions of the counsel and the status of proceedings before the arbitrator, this court is of the view that a short date may be fixed to decide the application, as no prejudice is likely to be caused. So, Milords,
there was no interim order.
No interim
there was
order.
no bar for the arbitrator
Yes,
to proceed.
yes.
Then-
There is no bar, Milords. Now, second, Milords, next page, your Lordship sees. The fourth, last paragraph, Milords. Learned counsel for both sides submits that the matter before the arbitrator will not be pressed. Consent.
Based on
So and so, as the parties are considering the scope of settlement and prays for the matter to be come up on the same date. Milords, the next order thereafter. On 21/10/2024, Milords, last penultimate Milords, paragraph, learned counsel for the respondent submits that the matter before the arbitrator is not being pressed, as at the moment parties are exploring a scope of settlement. So the arbitrate, Milords, there
But
was.
then, you see, there is no bar, there is no restraint order passed by the.
No, I am not saying that there is a restraint order passed by the commercial court. I am saying that when the party itself is saying that I am not going to press the arbitration in view of the pending Milords challenge, then there is no question, Milords. And just sees, Milords, the last order of 22/8/2025 at 203.
So but these are all orders of 2024. See, enough
No,
time
Milords,
has
25.
left.
25.
See, all these orders which you are referring now, these are all 2024 orders.
Milords, let's just seize 203. That is 22nd of August 2025.
Yes.
Learned counsel for the respondent submit that it shall intimate the arbitrator about the challenge of the mandate of the arbitrator. It is the intention is absolutely clear that till
all right, but then you see why there should be a restraint order which we have to return it by seeing whether you see like there is an implication or not. It has to be expressed. Either you stop somebody to functioning or allow him to.
Yes,
function.
but ideally
It is not there.
it should have been passed.
See,
it should have been passed.
What appears that all along whatever way the matter had proceeded, that is just because of the conduct of the parties. The way party wanted it to move, that has moved like this. But then you see,
Milords,
there
but
was-
at this stage, what I am saying that if this petition has to have any, today the arbitral award has not been passed. There is no proceeding pending before the arbitrator. The only restraint is that you shall not pass an award till the time this honorable court is considering the matter, Milords. Otherwise, what is the purpose of Milords, my challenge to his mandate? If tomorrow I succeed in this petition, Milords, then there would be nothing left. His arbitral award would be already out.
Even later also, even after passing of the award also, if you succeed here, this award,
Award will not go, Milords. Then I have to challenge it under section 34.
Then it will strike at the root of the power.
No, Milords, then there has to be a section 30 because that is covered by section 34. Entire proceedings, Milords, will go. The list before your lordship will no more survive.
So
And
all the subsequent orders, there is no indication, no 25.
because, Milords, they agreed that they will not press with the arbitration. And then the award was reserved. There is no question of a stay when the party itself says that I am not going to press with the arbitration. If tomorrow, Milords, in any arbitration, if one of the parties who is presenting before the arbitrator says that I am not pressing with the arbitration, then there is no question of stay. But today he has reserved the award. And if he passes tomorrow the award, this matter becomes infructuous.
And that means
And-
since
and
submission
today-
is coming from your mouth, that means you have the information, whatever is happening there in the.
And Milords, kindly sees the order dated 12/8 that the learned arbitrator has passed and is annexed at page 214. annexed at page 214, my lords. Para 7 at 216. As the hearing is concluded today, final award will be passed on a date notified by the to the parties. So final award, what I am saying today is that your lordship is considering whether the arbitrator is proceeding in accordance with the Arbitration Act or not. Whether his appointment itself is in accordance with law or not.
This is order dated 12/8/2025.
Yes, my lords.
So you should have challenged it.
No, my lords, the impugned
also you have not pressed for any stay of the proceeding.
No, my lords, impugned order itself is passed on 19th of September, and today, my lords, we are on the 24th of September before your
So
lordship.
far as the order of the arbitrator is concerned, order dated 12/8/2025.
12 thereafter, my lords, your lordship said
After that order, you were clear that the matter will proceed
and that
some order will be passed there.
That is why, my lords, on 22nd of August 2025, the learned commercial course asked the respondent to intimate that my challenge is pending. On page number 203, your lordship has seen, learned counsel for the respondent shall intimate the arbitrator about the challenge. What does it mean? It means, my lords, the matter list is pending before a court which has a supervisory jurisdiction over the arbitration tribunal. You shall not proceed.
You cannot go into.
So, my lords, my contention is that independent of these three orders, your lordship has the powers to ask the arbitrator to hold its hand till the time the matter is taken up before your lordship. And
No, there is no question of having power or not. There is nothing such.
Right.
The thing is that will it be proper to do it? When you yourself, by your conduct, have never sought for stay of the
No, my lords, it is sought. Kindly see my petition. Kindly see my petition.
No, see what petition? See the order sheets. Nowhere.
No, my lords.
Nowhere you have pressed for stay.
No. What has the at the time when the petition was pending, that time the arbitral tribunal was at the stage of filing of the statement of claim.
See, kindly. See this, even after that order of 12/8/2025 of the arbitrator, where it was made clear.
Yes.
The final award will be passed on a date to be notified.
Yes.
Thereafter also you should have at least.
Well, also on the 22nd of August thereafter.
That is only an information, nothing.
No, my lords. So I am not saying my right emanates from the orders of the commercial court. My right emanates from my challenge before your lordship. The challenge is to the jurisdiction of the arbitration tribunal. If a tribunal's jurisdiction is challenged, then why shall the proceedings and the judgment be passed by that? Why shall this court wait for the judgment to be passed by that court, my lords? So,
who is appearing for the other side? Who is the respondent?
My lords, respondent was represented by Mr. Pathak.
Okay, you are the department.
No, I am the department, my lords.
You are the department. You are the owner.
I am the owner of the project.
Not Mr. Pandey. There is a miscase also.
Yes, my lord, miscase.
Not Mr. Pandey. In the main case, not Mr. Pandey. Issue notice, returnable in 3 weeks. Petitioner shall take steps for service of upon the. How many respondents are there?
There was only one respondent.
Upon the sole respondent. Within 2 days. List after 3 weeks. Come to the miscase. How many miscases are there?
Because one is for exemption from filing certified.
You should have pointed out that before.
Yes, my lord. There is an exemption because
we should go step by step, isn't it?
Yes, my lord. Yes,
Then?
my lord. That is, my lords, exemption is MCCRP 16. MCCRP 16.
CRP, yes, right. Hard. Learning counsel for the petitioner. Stop by this application. The petitioner has paid for exemption from filing the certified copy of the judgment and order dated 19/9/2025, passed in commercial arbitration case number 9 of 2025, which is subject matter of challenge in the accompanying CRP number 22 of 2025. Step. Paragraph. Considering the urgency involved in the matter, the petitioner is exempted. Petitioner is granted exemption from filing the certified copy of the impugned judgment and certified copy of the aforesaid impugned judgment order dated 19/9/2025, with the condition that the same should be produced before the court. With the condition that the certified copy of the same should be produced before the court as soon as it is obtained.
Well,
Stop. The application. With the above, the application stands disposed of. These disposals here 16.
16 laws.
Then come to wait. How many miscases are there?
There was 2 miscases.
There is 16.
16 and then there is MCCRP 17.
Yes. How? This is also hard, Mr. and the learned counsel for the petitioner. Come on, by this application, the petitioner has prayed for stay of arbitration proceeding bearing stay of proceeding of the arbitration proceeding number. Petitioner has paid for stay of the arbitration proceeding number. You will write it like that, okay? Do not repeat the thing, okay? Number 02 electricity, you will get it in the miscase, in the prayer you will find it. Okay? Give the number plus so and so versus so and so also is there. Just see. Okay? Yes. The next paragraph. The learned counsel for the petition, learned counsel for the petitioner. Submits that the sole arbitrator in the arbitration proceeding was appointed unilaterally by the respondent against the basic principle of law. Stop. He submits that such appointment also raises a question about the independence and impartiality of the arbitrator insofar as the conduct of proceeding before him is concerned. It is further submitted by the learned counsel. Challenge to the appointment of the arbitrator was wrongly rejected by the landed commercial court, inasmuch as the commercial court failed to appreciate the provision of section 12 within bracket 5 of the Arbitration and Conciliation Act 1996. It submits that the landed, it is also contended that the impugn judgment of the commercial court being contrary to the settled provision of law, requires to be interfered with this court. And therefore praise that the arbitration proceeding number so and so be stayed till the pendency of the main revision application. Stop. From next paragraph, from the perusal, from the submission made by the landed counsel for the petitioner, and on perusal of material records, it appears that the matter requires elaborate consideration by this court. Stop. Hence, for the ends of justice, it is directed that no, where is that order dated you referred to?
Yes, Manoj.
The arbitrator?
That is another 214.
214.
Yes, Manoj.
What is it? Hence, comma, for the ends of justice, comma, it is directed that no final award shall be passed in arbitration proceeding number 03 stroke electricity stroke ML stroke 24. You'll get it there, okay? What is it? No, if the same has not been passed. If the same has not already been passed, if the same has not already been passed, comma, till the irretrievable date. Okay, then just give a paragraph. As this order has been passed in absence, as this interim order has been passed in absence of the respondent, comma, liberty is given to the respondent to file an application seeking modification stroke alteration stroke vacation of this order. Stop. Then list along with the main case.
Highly obliged.
Let us see what happens.
Yes, Manoj. But because it's a
this court knows nothing about arbitration.
Yes, Manoj.
But
But
it solely goes by what you say.
But my lords, at least one thing I can assure, and the manner in which it was litigated before the commercial court, both sides wanted an adjudication on this because considering the uniqueness of the issue involved in this matter, my lords. So, my lords,
What surprises this court is that how could this arbitration proceeding could go on,
yes,
despite the fact that the challenge to the appointment was made immediately.
Yes, my lords. Yes,
That is what surprises.
Yes, my lords.
So we do not know. Let us see. Let the other side tell us best.
Obliged.
Item number 2.
Yes, another arbitration matter.
Because now after Commercial Court Act, my lord, all disputes involving set above 3 lakh rupees will go to the Commercial Court, and therefore in all high courts, my lord, lordship will find that the court is flooded with the arbitration and commercial matters.
We should have a designated bench for that.
Yes, my lord. There is a notification issued by the High Court.
At least you would also, you see, feel comfortable arguing before a bench.
No, my
which
lord,
can appreciate your submission.
No, my lord, because what I feel is that the judges who are not initially familiar with the subject, but over the period of time, because we are all students of law, they become familiar and they become.
That has to be, see, the compulsion is there.
We become, and that's our niche, because that is how we have
also. The problem
also.
is that, you see, judge has to decide a matter in his initial stage also, later stage.
Yes,
so that is what,
that is how we have to
see. So
grow.
that is what, you see, the judgment should not suffer because of any of the deficiencies. Yes, Mr. Jindal, you were supposed to.
Lordship.
Yes.
I again go back to section page 68, paragraph F.
Just a minute. Yes, please.
Yes. So far, the award of the claim on the claim is concerned, we have no dispute.
Yes.
I just read in middle of the
yes.
Paragraph F. We also award and direct that the respondent shall pay simple interest at the rate of 12% per annum on the awarded amount of rupees so and so against claim number 126, and the awarded amount of rupees 5,32,096 against claim number 7 from 5/7/2013 and from 21/3/2015 respectively, being the dates of submission of SOC for claim number 1 to 6 and claim number 7. Then your next thing is important. Till the date of payment of the awarded amount. Till the date of the payment of the awarded amount. This up to this, it is a pre-award.
So that is yes.
Pre-award. I am coming to you. By the respondent to the claimant within 90 days of the receipt of this award, this rate of simple interest at the rate of 12% would however increase 12% per annum, a maximum of 12% per annum, subject to a maximum of
so we are not concerned with this later part. Now that is what the part which you have pointed out just now.
Lordship.
That this should be paid within the period of
90 days.
90 days.
90 days.
Okay.
90 days. That segregate the pre-award
yes.
and the post-award.
Yes.
So far the post-award is concerned, it is not in dispute that the arbitrators have not awarded the post-award interest. Post-award interest is awarded.
And it is uniform for the entire amount.
Entire amount, so, and with a rider that if the payment is not made, if the awarded amount is not paid, it shall carry
Yes,
further
but then
interest of 2%.
that will be also on the entire amount.
Entire amount, awarded amount.
Yes.
Now, in this matter, Your Lordship,
Yes.
there are two things which have to be seen. What does the awarded amount means? Because tribunal has not used the word principal amount. They have used the word awarded amount. And second thing, Your Lordship, which my learned friend is banking too much. According to him, since simple interest is awarded, the tribunal has exercised its discretion to award simple interest. This proposition is also not correct, Your Lordship, because simple interest is awarded in relation to what? Supposing the award says, or the act says, that the court may award the compound interest, and instead of compound interest, the tribunal awards the simple interest. Then, Your Lordship, it can be a case of exercising the discretions. Otherwise, it is not a case of exercising any discretion, Your Lordship.
Court has got your point.
And Lordship, another thing which my learned friend has, in the last moment, has pointed out, that simple interest is awarded by the tribunal, and the tribunal has calculated the post-award interest by taking into consideration the pre-award interest also. And therefore, it is a case of awarding interest upon interest or awarding the compound interest. And in support of this proposition, my learned friend is banking on that.
Probably what this court got from the submission of the AG is that he did not say that the interest cannot be granted. What he clarified is that the initial position was that the initial the law till this
SL case is there.
Okay, so it was not permissible.
Yeah.
And then subsequently, by virtue of the judgment in the High Court consultation, it was made permissible.
Yeah.
And the last decision of Morgan says that the arbitration has the jurisdiction to do that. So that is, there is no bar per se. He has never pleaded that.
No, Your Lordship, that's what that's what I am submitting before Your Lordship. That his contention is this: that simple interest is awarded by the tribunal. Now, tribunal, the parties have calculated the simple interest so far till the date of the award. Now, by adding the interest, pre-award interest with the principal, it becomes a case of awarding interest upon interest. That is what his submission.
No, but then is it bar? Even if it is correct,
yes.
Is there any legal bar in it?
The legal bar is there.
He never said so.
This is not my submission.
That is not his argument.
This is not my argument.
Sir, probably you have not got him correctly.
No, I have, of course, heard him, but what he intended, I have taken it in that way. Anyway, Your Lordship will, I was on the point of referring to the judgment of Hyder Constructions.
Yes, that you have dealt with.
No,
now, your next thing
one
was
part,
needed.
Your Lordship, one part is left out. Let me clarify that part also.
You have read till paragraph 21.
Justice Sappre's
Justice Sappre's judgment. I was on Justice Sappre's judgment at page 31. I have had the benefit of reading the scholarly judgment of my Lord the Chief Justice as also my learned brother Bob the Justice. With great respect, I find myself in complete agreement with the reasoning and the eventual
You read out all
conclusion
those things yesterday.
arrived at by Brother Bob the Justice. Even though the judgment delivered by Brother Bob the Justice encapsulate everything of what is required to be said, I, however, looking to the point in bold and very ably argued by all the learned senior counsel, which so wish to record my own reasons in addition to what has already been laid down. Reiteration of fact is unnecessary. The only question Your Lordship Justice Sapre has posed another point that the only question that arises for determination in the instant list is this: whether grant of interest by the arbitral tribunal under section 31(7) of the Arbitration and Conciliation Act 1996 amounts to granting interest on interest. That was actually, Your Lordship, he was trying to take me. That that question is answered by Justice Sapre. Now, the aforesaid question can be answered by a plain and simple reading of section 31(7). I skip section 37 and and I take to the finding at paragraph 30 and 31.
Yes.
Therefore, I am inclined to hold that the amount award under section 31(7)(a) of the Act, whether with interest or without interest, constitute a sum for which the award is made. Paragraph 31 is important, Your Lordship. Coming now to the post-award interest, section 31(7)(b) of the Act employs the word a sum directed to be paid by an arbitral award. Clause B uses the word arbitral award and not the arbitral tribunal. The arbitral award as held above is made in respect of a sum which includes the interest. It is therefore obvious that what carries under section 31(7)(b) of the Act is the sum directed to be paid by an arbitral award and not any other amount, much less or under the name interest. In such a situation, it cannot be said that what is, Your Lordship will just mark this word.
Yes.
In such a situations, it cannot be said that what is being granted under section 31(7)(b) of the Act is interest on interest. That is the answer, Your Lordship, given, rightly answer, that when for the purpose of calculating the post-award interest, the interest, pre-award interest is merged with the principal amount, that cannot be said to be that the tribunal has awarded interest upon interest. I hope I am clear on this, Your Lordship. Under clause, in such a situation, it cannot be said that what is being granted under section 31(7)(b) of the Act is interest on interest. Interest under clause B is granted on the sum directed to be paid by an arbitral award, wherein the sum is nothing more than what is arrived at under clause A. I may read 32 also. Therefore, in my view, the expression grant of interest on interest while exercising the power under section 31(7)(b) of the Act does not arise, and therefore the arbitral tribunal is well empowered to grant interest even in the absence of clause in the contract for grant of interest. Then, Your Lordship, I come to the Morgan case, on which heavy reliance
Before this, just tell us one thing.
Lordship.
Now, when there is a dissenting judgment,
Lordship,
and the majority view,
yes, is upheld again by a 3-judge bench.
Say
UHL
supposing-
power.
Just a minute. Probably, you see, like the court is trying to communicate it properly to you so that you can give us proper, the expected reply. Now here the judgment by Justice Sapre supports the view of Justice Bobde.
Yes.
Now it is not that the Justice Bobde is supporting the view of Justice Sapre.
No.
Isn't it?
Yes, that's true.
Now if we are to use this proposition,
Lordship.
what happens to this proposition which Justice Sapre has laid down? Can it be taken as a majority view in the judgment?
Your Lordship, technically speaking, it has to be taken as a majority view. Majority view. Because
there is no indication in the judgment that view is supported by
majority. That's why, Your Lordship, I have not read the dissenting judgment, because that may be good, better than what is Justice Sapre and Justice Bobde have held. But since it is a dissenting, we have to ignore that.
No, say, supposing if for a High Court, if it's to
Lordship.
follow certain proposition from this judgment,
Lordship.
now can the High Court
Yes.
regard this view
Yes.
of Justice Sapre as the majority view? in the
Certainly,
judgment?
certainly, yes. It has to be taken. It cannot be said that it is the minority view.
No, this aspect has what is falling from your lordship. This very aspect has been considered by Morgan, my lord. Whether
Let's see
view of
Morgan
Justice
also.
Sapre, view is view of the majority. What is his view? That entire aspect has been explained in Morgan, my lord. What the question which has fallen has been answered in Morgan. My friend is placing that judgment so that.
Before that, Your Lordship, the judgment of Haider Consulting has been, you see, Lordship, forms is again upheld by a 3-judge bench in the case of UHL Power Company Limited, page 54.
Only one submission I have to make. I do not disagree with the proposition of my learned
Exactly,
friend.
that is what the understanding of this court
And
was.
I agree whatever is held in Haider is correct. I have no, because I can't, this is a 3-judge bench. Now the issue which is before your lordship, according to me, is whether the arbitrator has exercised the discretion in granting the interest on the part sum or not. That is one question which falls for. The second question which falls for your lordship consideration is, what is the difference between my friend and my stand is this much only. What he says, what the submission of London Senior Counsel is, that the interest in the pre-award period has to be added in the sum. And in the post-award, the arbitrator has no discretion but to award interest on both components. That is the difference of bone of contention, because that will simplify the issue.
Yes,
that is what. You see,
give
your
me an opportunity to just
here the disagreement between the parties is that aspect. Whether the pre-award interest will get included
is mandatorily, as per Mr. Jindal's submission, it is mandatorily included.
Mandatorily included.
And my submission is
this is neither he can do nor I can do.
And my submission is that the Morgan has clarified that it is not a mandatory thing. That's the only thing.
That is what I am. You have made it clear yesterday.
Then, Your Lordship, I do not refer to the other judgment, 3-judge bench
You
judgment.
just if you want to deal with the Morgan judgment, then you can do it. Otherwise, see, so far as right from the beginning, probably
yes,
this court.
Let's straightway, Your Lordship, come to the Morgan judgment.
The learned AG has not disputed any settled proposition so far as this judgments are concerned.
Let's come to
His
the
thing is
straightway
that
Morgan
power is
judgment.
vested with the arbitrator.
Yes.
And the interest can be awarded or may not be awarded. That is what it is. That is where we are much more concerned with.
Yes, Lordship. Morgan.
Language used in the award. And the
Lordship, page 139 of the compilation of judgment of my learned friend.
how long will it take, Mr. Jindal?
Another 20 minutes to half an hour.
So this court has to rise because they will be sitting and again in the division bench.
Yes.
And then after you finish, probably
Only 15-20 half an hour maximum.
so altogether it will again come about 1 hour.
So,
Are you free tomorrow?
tomorrow I'm free. If you
Yeah,
are free,
subject to convenience of
yeah,
lordship.
otherwise it will go from my mind also.
Subject to convenience of lordship.
Exactly, no, not from your mind. This from this court's mind also. That is
Because now we are reading the judgments every day. So
okay. We'll just continue tomorrow then.
Grateful.
Continue is not difficult. It will be all right for you.
Yes, my lord. I have no issue.
No issue.
Okay. The Hard Land Council, or Hard Land Senior Councils. The hearing could not be. Hearing remains inconclusive. To continue. Further hearing to continue. Tomorrow, give tomorrow's date.
Yes.
If I may, have your
Yes.
lordship's indulgence. The item number 1 of the regular list, Lord, today, unfortunately, I was not there. I got a little delayed. So the matter was adjourned on the prayer of the my friend on the other side.
And for the respondent to mention.
It was adjourned because I think senior was not available. Milord.
Yes.
So I have no problem with that. Only Milord, there was an interim order. So earlier it was continuing. So Milord, my only request is that the interim order may continue.
There are two. One is a miscase. Interim was passed in a miscase. So we'll just extend it. Just in the miscase, you just say the list it along in the main case. The interim order passed earlier. Continues to the next.
Hello. Hello.
Yes. There will be more hearings.